Thank you, Mr President. I rise to speak on the Petroleum Reporting Miscellaneous Amendments Bill 2026 that we have before us today at such short notice, and I do so, as I said in the previous debate on the suspension of standing orders, I do so very reluctantly. And to put on the record here in this record of this debate, I do not think we should be dealing with this bill under these circumstances, rushed through tonight when we have not had a chance to properly consider it. People can refer to my remarks in the standing orders debate to have a more full understanding of my concerns about that. I'm particularly disappointed that we haven't had time to fully consult with people who have reached out to us as key stakeholders affected here, who quite understandably are keen to really know what this bill's about and how it's going to affect them, and want to potentially be able to interact with us about our decision making on the bill, about potentially even, I would imagine, things like amendments or whatnot. We haven't had the chance to do that, even though we've had those stakeholders reach out to us directly by email, and that's actually quite derelict in this place that's been the case. Apologise to those stakeholders that we haven't been able to provide an opportunity for them to be dealt with respectfully. Having said that, of course, we don't want to be in a situation of having to do anything for a situation here in Tasmania of fuel shortage that is going to be urgent and an emergency. Of course, we want to be prepared for that. We don't want to be caught short. I do think this bill really has two tranches in it, if you will. There's one that definitely did need to be done quickly, and it would have gone through this place in a flash with no problems whatsoever. That was the measures to do with being able to direct information to be provided and those penalties being increased for those recalcitrant companies that are being difficult about providing information at the moment. That would have flown through. But some of the other things aren't as urgent. They're not as urgent about securing our supply and could have waited either till next week or possibly even till next month when we're back for another sitting week. But the government wasn't prepared to consider splitting the bill. We could vote against clauses to give effect to that ourselves in this place. That'd be messy and scrappy. I would have questions too about whether, if we've struck clauses out of the bill, can they be brought back in another bill later in this term of government or not? I don't know. There's rules about that here that we haven't actually had time to get advice on how the rules of this place would apply in that situation. So here we are again, up against the wall really with this. Nowhere to go when you're not given time to even get the right information and inform yourselves as to your options. We do often have things available to us here to be able to be masters of our own destiny in this chamber. But of course it still does depend on the will of the chamber. So it's been the will of the chamber that we deal with this tonight. I do note we have actually probably all made a mistake in referring to the fact that we all would have needed the Premier to decide to recall us in this place to deal with this another time. In fact, this place is a master of its own destiny. We could have recalled ourselves, actually. We could have, at the time we were adjourning and setting the date of next sitting, this chamber can set its own date of next sitting, I believe. The clerk's giving me a note. We can. We can recall ourselves to this place by setting the date.
Well, off you go.
Well, we're not adjourning, but something for us all to remember next time. It only occurred to me when it was pointed out to me after it was all done and dusted with our debate. But quite frankly, if we'd adjourned this debate and we adjourned to the next Tuesday then, or whenever, we could have come back ourselves under our own steam. It's actually not the Premier's decision when we sit here. It's this chamber's decision in terms of setting the date of the next sitting. So let's all keep that front of mind, shall we, for future reference. I'm not going to go through the bill in detail part by part. It's the government's job to do that. They've done it to some extent. Other members have spoken to parts that they were particularly interested in. I am also concerned about the price cap capacity and unintended consequences and how that's going to be managed. I am also, as the member for Murchison mentioned in her contribution, her concerns around the inequitable impacts of these things and whether we are best supporting all those who might need to be supported. That's going to be an ongoing question, not necessarily dealt with by matters under this bill, but it's certainly for all of us to be aware of, and the government. Well, I think the government should have to be answering regular questions about how they are managing the equity impacts of this situation if it does proceed into particularly emergency sorts of scenarios and pretty drastic measures having to be brought in. If we get into that space, I hope we don't, but if we do get into that space, equity is a really major concern. We know that Tasmania has big divide in the community when it comes to resources and how well people are able to withstand different sorts of shocks. And it generally does need more than just tweaks around the edges like half-price bus fares to be able to actually materially smooth out that inequity. So that's something for us all to be monitoring, I think, going forward, regardless of the particular provisions of this bill. Just to say, I'm just double checking my notes, Mr. President, to make sure there weren't any other particular things I wanted to go to. Just to speak briefly, and of course if we get to committee stage, as others have mentioned, and as I had foreshadowed, I do have an amendment for clause 19 of what is now clause 19 of the bill. And it is on a topic that is a broad principle concern for me, a concern that's principle-based, I suppose. And it's to do with parliamentary oversight of the executive, and it's an area that was very much brought to my attention at the time we went through the COVID emergency and we had to legislate under incredibly difficult circumstances there. And after that experience, it's always been for me quite a front of mind concern to always look for opportunities to strengthen parliamentary oversight of the executive or to address areas or times when that has not been dealt with as robustly as it should. No executive likes parliamentary oversight, of course, Mr. President, so they're unlikely when they bring legislation through this place to have put in things as robustly as others like myself might like. So I'll speak to my amendment in more detail when we get to that stage of things in the committee, when we're in committee. Suffice to say, I've tried to approach it in a way that didn't make changes to the government's drafting of their elements of the bill. I could have approached it in that way, but I deliberately chose not to do that, but to try to come at it from a slightly different angle to be able to achieve that greater certainty about oversight without disrupting the government's intentions and decisions about time periods, for example. So that we'll come to that more, Mr. President, in the committee stage. I think that's all I'm going to say in terms of my contribution on the bill. Of course, there would and could be much more to say, but I don't have time to have contemplated it properly, to have researched it, to have consulted with relevant stakeholders, to have gathered my thoughts effectively, particularly not at this stage of the day. So I'm disappointed in that, and it's a shame to feel that you are legislating in a way that is far less than ideal when we're tasked to be here to do this as a responsibility on behalf of our Tasmanian community. So, Mr. President, on that, I will leave my contribution.